Welcome to the Wright Family Law Divorce Podcast with your host, Ellen Wright, family law attorney, divorce coach, entrepreneur, and motivational speaker, discussing all things divorce and helping you learn to keep the pain of separation from holding you back. And now, your host, Ellen Wright.
Welcome to episode 4 of the Wright Family Law Divorce Podcast. Today, I have with me Alethea Shaddix, who's a domestic relations attorney here at the Wright Family Law Group, but she's also a bankruptcy lawyer who assists our sister law firm, Express Bankruptcy Solutions, in processing bankruptcy petitions for individuals and families who are in financial crisis. And we're going to be talking about the intersection of bankruptcy and divorce and what that looks like for people who are facing the prospect of both or maybe one or the other, and the different phases of the process depending upon what their particular family situation looks like. So welcome, Alethea. We're so glad that you were able to carve out the time to join us today for this podcast.
Hi, thank you so much for having me.
So Alethea, take us through what a Chapter 7 and a Chapter 13 look like.
So a Chapter 7 is a liquidation chapter. When someone's filing a Chapter 7, they're disclosing all of their assets and all of their liabilities to the bankruptcy court. At that point, you have to determine whether or not all of their assets are exempt. If some of them are not, then the trustee would potentially liquidate them, use those funds to pay the creditors. Chapter 13, you're going to be paying part of your debts back based upon your disposable income. So that becomes a very complicated math problem where you're putting in your income, deductions, things like mortgage, car payments, and then there's a lot of things that are in there that are IRS standards depending upon where you live. So whatever your disposable income is going to be what drives your Chapter 13 plan payment. The first question to ask at the outset is how much money does the client make? Okay, if they're over the median, they're going to be a Chapter 13. If they're under the median, they can possibly do a Chapter 7.
What's the median roughly?
In Massachusetts, for a household of one, it's 72,000. It changes every so often.
Mm-hmm.
So I've...
Is that with kids or without?
That's a household of one. So it depends on... they'd have a whole chart. It's on the irs.gov website.
Okay.
And it will tell you every state and what the median is depending upon your household. So if you start from 1, it being 72, and then a household of 2, it goes up maybe around 90,000 maybe. I don't know them offhand because they change so much, but right. A household of 1 is 72.
Okay. So these bankruptcies, we're focusing on a Chapter 7 and a Chapter 13. There's different chapters in the bankruptcy code, but That's basically what you're doing for individuals and families.
Yes.
Pretty much.
Yeah. Typically, it's going to be a 7 or a 13. A Chapter 11 is for a large business reorganization. Don't really see that around here too often. And then there's other chapters that apply to farmers and fishermen that I've never dealt with in this area, of course. So,
got it. So with a bankruptcy, we've got 2 primary objectives, leaving sort of divorce outside of the purview for a moment. Mm-hmm. The purpose of a bankruptcy is to provide a debtor with a fresh start and to equally divide the debtor's non-exempt assets among the creditors, right? So when you're dealing with people who are just in over their heads with credit card debts, they've got medical bills, they've got student loans, maybe they've got a car payment that they really just can't afford.
Yep.
Okay. What's the first thing that you look at when they come to you and they say, oh, by the way, things aren't going well with my husband or wife? I don't know if this is something that we should do together. Mm-hmm. We may be filing for divorce. What do we do?
Well, it's going to depend on a number of factors. Sometimes it might be cleaner to file a bankruptcy first and then proceed with the divorce after, but it's going to depend on, you might not be able to get the people to hold off on filing a divorce. They might need to do it right away. They might not be able to live together. I don't know. The other thing that you would need to keep in mind is what is the income as a household while the parties are living together with all the kids in the house. That's gonna make the household income be able to be larger than it would be if the parties split up. So if somebody might might qualify to file a Chapter 7 if they're married. If they divorce and separate the two households, then there might be too much income in one household, which is going to make one need to file a 13.
Mm-hmm.
So you have to really get a good handle on how much each party makes, on both the husband, the wife, how much does he make, how much does she make, how much would it be if they split the households up, and determine from there what the best option is going to be. So it's not always a simple thing to figure out. You really have to, there's a lot of like pre-planning that has to happen before you can tell somebody, what's going to be their best option.
Mm. So I love to always, give my fair share of the war stories.
Mm-hmm.
And just to sort of quickly recap about that divorce case that I'm involved in right now with these people. So, husband and wife own a house. The interest rate was high on the mortgage.
Mm-hmm.
The monthly payment just really more than they could afford. But they were hanging on for years. They couldn't afford to maintain the house, and it just sort of fell into a complete state of disrepair.
They bought it together.
Yep.
It's in both their names.
Yep, both their names, yep. So wife, earned more money than husband. I think she makes about $80,000 a year, and the husband is lower wage earner, maybe $35,000 a year. Okay?
Yeah.
So she meets a boyfriend, moves out of the marital home. She's gone, leaving the husband behind. He hangs in there for about 3 or 4 months. She's helping him pay the mortgage, but eventually he abandons the house and moves in with a girlfriend a couple towns away.
Yeah.
So now we have this house that's just abandoned, sitting there, that's continuing to fall apart. Eventually, they both stop paying the mortgage. Wife filed for divorce. So she lawyers up, husband lawyers up, okay? And then the conundrum in the divorce is, what are we going to do with this house? Because no one has paid the mortgage. They are upside down, okay? We can't sell it. You can't do a deed in lieu of foreclosure because the bank doesn't want it. It's not habitable.
Yeah.
And they've got, like I said, the deficiency. They're going to owe taxes on the deficiency.
Yeah.
And they're in a squeeze. Now, we had bounced back and forth the idea of doing maybe a joint bankruptcy for them as husband and wife, but we cannot because they are in the middle of a divorce.
Right.
I mean, that is just not doable. And then we also entertained the idea of, all right, well, what if we dismissed the divorce, filed the bankruptcy, then resurrected the divorce. That's not going to work either because
now they live in different places.
They're living in different places with
different states, right?
Right, with boyfriends and girlfriends.
Yeah.
And husband moved to Maine. So you really can't give the bankruptcy court a good faith representation that they're married when the reality is
correct.
They're honestly not.
Yeah.
So then it's turning into one conundrum after another. But the reality is, I think that the debt is marital. In all likelihood, it's going to end up being a 50-50 split.
Yeah.
And, post-divorce, if we're ever able to get them through this, what would a bankruptcy look like for him and for her?
It's really going to depend on how the separation agreement is written. So I don't know how they're going to resolve the issue. Are they going to actually agree on that? Are they going to say, yes, it's 50-50, we're both equally responsible for this debt? Do they have other debt?
They had some unsecured credit card debt, nothing humongous.
Yeah.
Maybe in the $5,000 or $10,000 range.
Okay, so the only significant issue is really the deficiency on the house.
Right.
Yeah. Well, I mean, I don't know. It's going to depend, again, on how the separation agreement is worded, where they're both living, what their household income is at the time, because potentially they both file down the line to get rid of the deficiency. I don't know. But if one party makes a lot more than the other,
right,
then the party who makes more money and maybe is over the median might have to file a 13, where the other one might be able to do a Chapter 7 and get rid of it.
Right.
So that could be another hurdle for both of them. Again, looking back to see how the separation agreement is worded, we don't know who's going to take that liability.
Right.
Assuming they're both going to take it, it's not really going to be fair to one party if one gets to do a 7 and the other one's paying it back. So that's going to be something that you're going to need to talk. Each attorney for the divorce clients are going to need to speak to their clients about to see what they'd be willing to do in a situation like that.
So hiring an attorney for your bankruptcy and divorce. If you and your ex both need to file for a bankruptcy and divorce, I mean, logistically speaking, you might have to hire 4 separate lawyers, right? I mean, that can get really expensive quick. Yeah. Do you have any ideas or suggestions about how to avoid that?
Well, it's going to depend on the parties, if they're communicating okay. They might want to go talk to a bankruptcy attorney together first and see if that might be an option for them. I mean, in the long term, if it doesn't go that way and they both need a divorce attorney, they both need a bankruptcy attorney, it's going to be super expensive. That's why I would probably say if they can communicate, just try to work together on that to figure out what your plan is going to be, so you can better determine which path is going to work and which path is going to give you problems. Before you spend all the money on hiring these different attorneys, you want to have a plan.
Right.
And you need to talk to somebody. I'd probably say talking to the bankruptcy attorney first makes the most sense.
Mm-hmm. All right. When does it make sense to file a bankruptcy before you get divorced versus after?
So filing a bankruptcy before you get divorced, if it's pretty straightforward, you have a lot of joint credit card debt together, you're able to hold off on the divorce potentially, you're both still living in the same house, which very often does happen with people who are contemplating divorce, it might be cleaner and simpler to file a Chapter 7 if they qualify. You're going to be in and out of it in a few months, and then file divorce after you get discharged and the bankruptcy is closed out. So if it's a simple, relatively straightforward, not a lot of assets involved, like say the parties are married, they've got $50,000 of joint credit card debt, they don't have any assets, they don't have any house to split, any retirements to split, that you might be taking in a previously exempt asset and making it unexempt.
Right.
So that's not going to be a consideration. So in those particular circumstances, it might be simpler just to file the bankruptcy first, get the clients discharged, and they can both go on their way and file for their divorce. So that would even make their divorce simpler because the debt's already been cleaned up. Okay, they don't have to figure out who's going to take what, who's paying for which debts.
Right.
Okay?
Okay.
But when it's going to be more dicey is when there's a lot of assets to divide, because you have to be very careful about who's going to get what. Because if you have somebody at the beginning who they have a house together, and then you're going to transfer the house to, one of the spouses, and the other spouse is buying him out, you might be taking the asset, which would be the house, and converting it into something liquid, cash, if there's a buyout.
Okay.
That could give the other party an issue in a bankruptcy. So you really...
An issue how?
An issue because if they're filing the bankruptcy, then they would have that lump of cash maybe sitting in a bank account, or it being, the transfer is pending upon the refinance of the house. Mm-hmm. So it's now cash that you can't exempt, when previously in a bankruptcy, if they filed together, that house is both of theirs, you're exempting it.
Okay, when you say exempt, what does that mean exactly?
It means that there's different categories of property, and whenever you file for a bankruptcy, whether it's a 7 or a 13, you have to disclose what your assets are to the bankruptcy court and put a value on them, a reasonable value based upon the market. And you get different exemptions, whether they're federal exemptions or they're state exemptions, and that's another thing that you'd have to talk to a bankruptcy attorney about, is to decide which is more beneficial for your case. If property is exempt, for example, in Massachusetts, if you have a homestead, you can claim up to $500,000 on your house. So if your house is worth $500,000 and there's no mortgage on it, you can exempt the house entirely. So that means the bankruptcy trustee can't come in, move to sell the house to get that money to pay your creditors, because it's 100% exempt. But if you're in a divorce, that same house that you own together, if one party is buying the other out and they're going to get a lot of cash for it, say $100,000 for a buyout, just say, that's going to be sitting in a bank account and you can't exempt it all. You could probably exempt a couple $1,000 maybe, depending on what exemption scheme you use. So if you have property hanging out there unexempt, the trustee is going to try to grab it and use the money to pay the creditors.
Got it.
Okay?
Okay. Interesting stuff.
Yeah.
For sure.
So you have to be really careful about property division when you're contemplating divorce and bankruptcy, because something that may have been previously protected, say a 401k even, one party has a 401k and then they're going to transfer half of it to the other party. depending on how the other party takes that, maybe they take that and roll it into something. Okay, that's fine. That might be protected. But if they just take it, as cash because they want to put it down on a house, they're going to have an issue in bankruptcy because that's no longer, it doesn't have that exempt status any longer.
Right.
Okay.
So debts from the divorce. I mean, assuming you get through the bankruptcy process, will all of the debt divorce go away when I file bankruptcy? So let's talk about what is dischargeable and what is not. Let's say I'm low to median income and I qualify for Chapter 7. What can I get rid of?
You can get rid of your credit cards. You can get rid of all credit card debt, anything in collections, any lower court actions, default judgments, utility bills, phone bills, medical bills.
So if like Capital One sued me in small claims court for a credit card or something, and they went to judgment.
Yep.
And let's say they recorded the judgment or they were bringing me into court, chasing me down to that's going to go away?
That's going to go away. If they put a lien on your house, there's another step involved, but you could still potentially get that to go away in the bankruptcy. So you have to make sure that you bring that information to your bankruptcy attorney.
Okay.
But yeah, you can get rid of those debts. If it's just a judgment, it's going to go away. But if it's a judgment and they put a lien on a house, then there's another step. You'd have to remove the lien through the bankruptcy court.
Okay. So would that be a secured? If it's
secured, but it's a lien that would impair an exemption that you're entitled to take. So it's a separate motion that you'd be filing with the bankruptcy court to remove it.
Okay.
Okay.
So what's the difference between a secured debt and an unsecured debt when I'm looking at 7?
It's pretty simple, really. A secured debt is secured by something like property. So a secured debt's going to be a mortgage because it's secured by the house. A car loan, secured by the vehicle. Some creditors try to be aggressive about it and say that it's secured sometimes when it's not. Like if somebody buys furniture from Jordan's Furniture, the creditors will very often send out something saying, hey, are they going to reaffirm this? Because if they don't, we're going to come and get the furniture. And they really don't do that. They're just going to kind of threaten it because they want you to keep on paying the debt. So it's secured debts are going to be typically your mortgage, your car loans, and unsecured is just regular, straightforward credit card debt.
Okay. Interesting. I saw something in the news, and maybe I sent you the article. Do you remember if I did? It was like a couple of months ago. There was a law in Massachusetts. These they're selling like those pet shop dogs, like those pedigree dogs that you'd buy at like a pet shop or some of these places, and they were doing those secured loans to finance the dogs.
Oh, really?
Right? Yeah. So it was like $1,200, $1,500, $2,000, and so you'd make the monthly payments, but there was a secured interest by the financing company in the dog. And I thought I had sent you that article. It was like kind of an interesting.
I don't remember that one.
Yeah, I think the Attorney General declared it as unlawful or illegal to have a secured interest because I don't know, you default. I mean, not that anyone. I can't see a bank coming to take a dog.
I can't either.
But they were doing it. I mean, pretty surprising.
Yeah, that is actually.
So what if I have a car, right, and I'm married, and my marriage is terrible, right? I cannot stand this man. I like the car that he helped me buy, and I want to be able to keep it. We're both sort of struggling with our debt.
Yeah.
Divorce is a possibility. I mean, he can't really stand me either, but we sort of need each other. We're so financially intermingled.
Yeah.
I mean, if we filed a joint bankruptcy, what are the chances that I could keep the car?
If you're making the payments on the car's current, you're going to be able to keep the car. I mean, there's no reason why you can't. So maybe if you're not paying, if you get rid of the credit card debt because you file a joint bankruptcy, maybe that frees you up so you're able to keep the car. But you have to be able to afford the car. Okay, so, file a bankruptcy. Just because you owe that debt and you're listing that in your bankruptcy doesn't mean that you have to surrender the car. If you want to, you can. But you can keep on paying the car and keep it. You just have to be current on it. You can't stop paying the car as well.
So but you have to do like a sort of a household budget, right?
Yes.
For a bankruptcy.
Yep.
And if the trustee sees that I have this Cadillac that my husband is more or less paying for, it's like,
And you're filing it together.
Right.
Yep.
I mean, is that going to be an issue?
I mean, how long ago did you get it? Is it,
Let's say we got it 6 months ago.
I mean, you got it 6 months ago, and then the car payment's $1,000. I mean, it's going to draw a little bit of attention. But if it's a car loan that you've been in for a couple years, more often than not, it's just going to be like, okay, this is what they need. But a lot of people who file a bankruptcy look at that, and they actually kind of do this smart thing. They let go of their personal attachment to the car, and they say, let me get something more affordable. So they might surrender the expensive car through the bankruptcy and then get something else after or before the fact. That's more affordable.
So if you surrender a car you really can't afford, I mean, bankruptcy is going to hurt your credit. But does that hurt your credit? Is it sort of adding insult to injury in terms of...
Not really. If you're filing a bankruptcy, your credit's going to take a hit, or it's already taken a hit. So you might... When you're getting another car loan, you might get a higher interest rate, but that's going to happen either way. If you miss car payments, or if you're defaulting constantly, you're running late constantly, or you file a bankruptcy, either way, it's going to hurt your credit. Okay. So I don't really know that one is worse than the other, but the point is when you need to, look at your budget a little bit closer, figure out, does it make sense to keep this car just because I like it? You don't want to have this ridiculous car payment and you're foregoing other things that you need to make a car payment like that. So you look down the line and say, okay, what can I afford? Maybe $300 or $400, not $1,000. And then you'd surrender that car and get another car before you file the bankruptcy, or even after. You're going to have a high interest rate, but that's what's going to happen either way because your credit's already damaged.
Okay. How long does it take to rebuild credit after a bankruptcy?
It's kind of... I would say it really depends on what you're doing post-bankruptcy. So maybe if you take a secured credit card and use it carefully and, pay it off on time and all that, you'll start to rebuild your credit. It's really not as damaging as a lot of people think that it is, because I think that, this is just my opinion, I think that the market is so saturated with, credit that they're much more willing to extend credit to people than they were before who have poor credit scores, but they'll just give you a higher interest rate. So, I mean, I know of clients who have filed bankruptcy and they get credit card offers pretty quickly after they're discharged. They're not going to be the best offers. They're not going to be 0% interest with, a $10,000 limit, but they will get credit offers fairly quickly. In terms of getting a car loan, I mean, I think you're always going to get a car loan because it's secured. Right. So they know they can come back and make a lot of money off of you in interest, and then come back and get the car if you don't pay it. But maybe I would say that you're going to see a bigger increase in your credit score after probably 2 years is kind of like the threshold window.
What about if I have to separate from my husband and I have to get an apartment? I need first, last, and a security. And a lot of these landlords look at credit scores.
They do.
Right?
They do, and it can be an issue.
File before, after? I mean, what's sort of like the best course of action with that?
Well, if you file before, there's the argument that your slate is clean and you don't really owe the debt, so clearly you can afford to pay your rent. Whereas if you're tied to all this debt that you're trying to scramble together to pay monthly, you don't have that extra money. But at the same time, they can deny you based upon they're not supposed to deny you based upon a bankruptcy filing, but they can find another reason to do so.
Right.
So all I can tell people in that situation is it's going to be, a lot of landlords are going to kind of go with their personal gut, and if they think it's a good risk, they might take it. But if you're applying to a complex, that might be where you run into an issue if you can't get a cosigner. But if you're kind of going for the private landlord who has a house, you have a better chance, I would say.
Enjoying this episode of the Wright Family Law Divorce Podcast? Be prepared to face the tough questions about debt and divorce by downloading our complimentary e-guide, 5 Secrets You Need to Know About Divorce and Bankruptcy for more helpful information. Click the link in the show notes or go to wrightfamilylawgroup.com/guides. That's wrightfamilylawgroup.com/guides and grab your free copy today.
So we know that domestic support obligations like child support, alimony, obligations to pay future educational expenses for children, as well as obligations to pay future health care costs for kids, obligations to make monthly payments on a mortgage or in lieu of a car payment, can be considered domestic support obligations and are not dischargeable. But the bankruptcy court looks at a number of criteria in the bankruptcy code to determine the nature of support and whether it falls into any of these categories. So, reading from section 523A5, the court looks at these factors to determine the nature of the support. 1, actual substance and the language of the parties' agreement. 2, the financial situation of the parties at the time of the agreement. 3, the function served by the obligation at the time of the agreement. 4, and whether there is any evidence of overbearing at the time of the agreement that should cause the bankruptcy court to question the intent of a spouse. The courts are always going to consider the additional following factors: the party's employment history and the prospect for financial support, whether one party received marital property, the number and frequency of payments, whether it would be difficult for the former spouse and children to survive without the payments, the length of the marriage, the economic disparity of the parties, whether the spouse who brings the complaint challenging the language is caring for the minor children, the age, employability, education levels of the parties, the label in the decree of the agreement, whether the obligation terminates upon the obligee's death, remarriage, or emancipation of the children, whether there is a waiver of alimony or support in the marital settlement agreement, the availability of state court remedies to modify or enforce the obligation, and last but not least, the tax treatment of the obligation. So, child support in a bankruptcy can still be modified by the family and probate court if the obligated party can show a material change in circumstances. And it's not unlikely that a party might use the bankruptcy itself or the circumstances that gave rise to the bankruptcy as their material change in circumstances. I think that's a key point. I'm the non-debtor spouse.
Yep.
And my debtor X filed a Chapter 13.
Mm-hmm.
Is there anything that the bankruptcy trustee can do to screw me?
Well,
in terms of a repayment plan, if he owes me back child support or back alimony?
Well, you're going to... No. If he owes you back child support, then that's going to be listed in the Chapter 13 plan. How is it going to be addressed? You know, how is he going to catch it up? Is he going to... the trustee has no interest in screwing you. They need to look at the plan and see if it's a conformable plan, if it's in the best interest of all the creditors, which would include the recipient of the child support. Mm-hmm. So if, the debtor's behind in child support, he's going to have addressed that in his Chapter 13 plan and propose a repayment.
Right.
So he's got to stay current on it and also make the payment secure the arrears.
So should I file a proof of claim?
Yes.
And how do I do that? Do we need a lawyer to do that?
You don't. You can. The forms are online.
Okay.
With the bankruptcy court, and it's pretty straightforward. It's kind of fill in the blank. But yeah, you're going to get notice. You should be listed as a creditor in the bankruptcy, so you would get notice from the bankruptcy court that you can file a proof of claim.
What if I don't do that on time?
If you don't do it on time, it could be excluded. But then that comes back to the question of it being child support, and I don't think the court would exclude it at all. So that's kind of a tricky situation, but I would file one just to be safe. The debtor's not going to get out of child support because one party didn't file a proof of claim, but it is just going to add a little bit more confusion to the case.
Okay. And the trustee is the one who oversees all of that?
The trustee oversees the case. Their job is to make sure that the Chapter 13 plan meets the best interest of the creditors test. So all the creditors in the bankruptcy should be getting payment based upon what the debtor's disposable income is and in the order of their status, whether it be secured, priority, unsecured.
Okay. All right. So what's the difference between a bankruptcy trustee and a bankruptcy judge?
The bankruptcy trustee is an attorney who's appointed to administer the case. So the trustee is just making sure that, whether it's in a 7 or a 13, is just making sure that all assets are accounted for, that the creditors get their fair share if there's anything to be either liquidated or, redeemed or surrendered in a bankruptcy. They have to determine whether or not the creditors are going to get anything back. They also have to determine whether or not the plan in a Chapter 13, whether or not the plan meets the best interest of the creditors. So the bankruptcy judge, they're going to come in to play if there's some issue that has to be decided that the parties can't agree on. So the trustee could file something, to claw something back in a Chapter 7, and if they can't reach any kind of an agreement, then they're going to be going before a bankruptcy judge. Okay?
There are situations, though, and I've seen this a couple of times, where an ex-spouse will file a bankruptcy after the divorce, right? And when he gets rid of a lot of the unsecured debt, child support payments aren't as hard to come by, and the child support is actually paid on time. I had one case where the guy was perpetually in arrears, right? Because he just couldn't get, his head above water. But once he got his discharge in bankruptcy, and a lot of these credit cards and other bills went away, he was actually able to get current with his payments. I mean, in a lot of situations, this is huge, right?
Yeah, definitely. Because if somebody's, strapped down trying to pay off all this credit card debt and they just can't do it, they don't have enough to live, it's going to affect every area of their life. So the things that they need to pay, their rent, their mortgage, their child support, their food, their utilities, if you're getting rid of all that unsecured debt that's holding you down, it's going to make your life a lot easier. So in a lot of cases, it's a good option for a lot of people.
What do you say to a lot of the people who are just embarrassed, right? Their marriage is falling apart, their finances are falling apart. Maybe it's embarrassing to file for divorce. I mean, that's embarrassing enough, maybe, right? But you file for a bankruptcy, and that's just, they've always, been raised to pay their bills and do the right thing. And, I mean, what do you think about the embarrassment and the shame?
I guess I understand it, but in the long run, it just doesn't make any sense to me, because there's no need for somebody to live that stressed out every single day when there's a mechanism that's going to relieve you of that burden. It's there for a reason. Right. Businesses file all the time. Wealthy people file a lot, just a different kind of bankruptcy, a Chapter 11. So you have to think about it in terms of if you're saddled by all this debt and you're embarrassed to file, you're not really contributing to the economy because you can't. Right. So that's kind of the reason, the theory behind the bankruptcy. If you kind of hit the reset button, start over, then you're going to be contributing to the economy again, which boosts the economy, which has a better effect for everybody. So you have to look at it in more big picture terms than your personal problems with it regarding morality and if it's right or wrong.
Right. Okay. And a lot of people, their financial hardship isn't their fault, right?
Yeah. I mean, more often than not, reasons for a bankruptcy are going to be a medical issue, a divorce. It's usually like an event in someone's life that changes kind of the course of their life for a little bit.
Right.
Yeah.
Right.
It's not what people think. It's not, people, I'm just going to rack up my credit cards and then file a bankruptcy. Like, that's really not how it works. I'm sure there's cases where it's happened that way. Right. But it's not the norm. It's kind of the exception to the rule.
I always think about Abraham Lincoln, right? He filed bankruptcy, I think, 2 or 3 times before he became president. He had some failed businesses and had a bad partnership.
A lot of people filed bankruptcy. A lot of
failure. Yeah. I mean, if Abraham Lincoln can do it, right? Yeah. Right. I mean, I think that it's fine for the common man. It's like you say, it's there for a reason, right? It's to help people get the fresh start that they need.
It's to keep the economy turning too. It's not right. I mean, it's bigger picture than just individuals. It's for the economy.
Right. As a few final closing thoughts about this whole topic, people's chances of surviving divorce and bankruptcy, no matter what, are going to be much better if they're able to communicate. I mean, communication is huge. Divorces are almost, well, I don't want to say almost always, but are frequently tinged with bitterness. And if you've got financial catastrophe sort of on the horizon, that isn't going to help people get along any better. I mean, that's just a reality, right? But if you've got people who can communicate, or maybe they can't communicate, but maybe their attorneys can sort of bridge the gap, I think it's going to go a long way in terms of resolving their legal and their financial issues, either in or out of family or bankruptcy court. I mean, what do you think about that?
It would, if a potentially divorcing couple has a lot of debt issues, it really would be beneficial to them if they can at least communicate about that piece of it to kind of work together to get a plan going. because if they don't, they're going to run into hurdles like that couple that you talked about earlier with the house, and now they're kind of stuck with this debt and don't really know where to go with it. So the more that they can communicate, I think the better off they'd be, because then they can explain those issues to their divorce attorney, to a bankruptcy attorney, and kind of set out a plan that's going to benefit them both.
Right.
In the long run.
Yeah. I mean, these people, they had no plan.
Yeah.
And, they had no plan, and they were not communicating.
Yeah.
And, again, filing divorce and bankruptcy at the same time is never the clean way to go. So I think, you want to avoid that at all costs. And good communication really is the best way to go about that.
Yep, absolutely.
All right, well, that concludes our episode on divorce and bankruptcy. Thank you so much, Alethea, for joining us today.
You're welcome. Thank you for having me.
And I'll see you next time.
Thanks for joining us today. Remember, the Wright Family Law Divorce Podcast is not legal, financial, or tax advice, nor should it be construed as such. We recommend that you consult a qualified legal or tax professional before making any decisions about any of the topics discussed in our broadcast. If you enjoyed this episode and you'd like to help support the podcast, please subscribe. To catch all the latest from the Wright Family Law Group, sign up for our email list and newsletter on our website at wrightfamilylawgroup.com. Thanks again, and we'll see you next time.